Yeah, I don't know what.
All right, ladies and gentlemen.
You're right.
Let me introduce you to the moderator and chair of this panel. If we can have your
It
attention.
can be dislocating, not.
Thank you.
Not just to go into the.
All right.
Place and reinsert.
Professor Waters from Washington University could not be with us today, and we're very fortunate because one of the people who play a huge role in our international law program, my colleague, Professor Tim Webster, has learned enough about deterring the use of child pirates to be able to really manage these experts well, and we're going to hear a very exciting panel. I now turn it over to Tim Webster.
Thank you, Michael. Thank you. And thank you guys all for coming. I'm sure you are as disappointed as I am that Professor Waters is not able to make it. She's a brilliant and wonderful person. But today, as Michael just mentioned, the panel is going to look at deterring the use of child pirates. We have an eminent and distinguished transnational body of experts here assembled to inform us about these issues. And this issue itself, the issue of child piracy, is, if I can use a bad pun, still in its infancy. Over the past 20 or 50 or 20 years, the prescription of child soldiers has really taken on a life of its own. And so the open question for us is, how are we going to develop a legal framework, or even are we going to develop a legal framework for deterring the use and the prescription of child pirates? We've talked about a number of different models. Our speakers will also highlight some of those models that they have written about in their own writings, both for this conference and outside of it. But a couple of the questions I think they will want to grapple with, or will want to grapple with in this session, is to what extent can the international law of child soldiers be applied to the problem of child pirates? Is that a good building block that we need to expand on? Is it something we should toss away and try to recreate anew? Sandy mentioned this morning about tribunal fatigue. Is there an international law child fatigue that may actually slow down the efforts of child piracy? So these are, the efficacy or the commensurability of the child soldier model, I think, is something that we'll want to discuss. We've also talked about the piracy model. To what extent do juveniles or child pirates fit into that? We've talked about, Ash Roach this morning was talking about the various conventions that can also be used to supplement UNCLOS and the piracy model as it's been memorialized in international law. To what extent can the piracy model also be used to talk about the child piracy model? We also talked about the Mauritius model, which is to pass comprehensive legislation on a particular issue. Is any state likely to pursue a similar model to deal with the issue of child pirates? And finally, in Professor Drumble's piece, which I recommend to all of you, he calls for a flexible model, saying, look, we don't need to set all these things down into stone. We need to look at each case contextually and determine what that particular pirate may or may not need. So those are some of the different models, some of the themes we'll be discussing over the next hour and 15 minutes. I'd now like to turn to our distinguished group of panelists. On my left, we have Professor Shelley Whitman, who's joining us here from Dalhousie University in Halifax, where she is the project director of the Romeo Dallaire Child Soldiers Initiative. She's also the deputy director of the Center for Foreign Policy Studies up there in Halifax, Nova Scotia. Like all of our speakers, she has a distinguished and brilliant transnational career. She has taught, she teaches currently at Dalhousie. She's also taught at the University of Botswana in Africa, and has worked for UN bodies as well, spanning all over the world. So we're lucky to have someone of her expertise and someone of her broad background speaking to us this morning. To her right is Professor Mark Drumble, who is the class of 1975 alumni professor at Washington and Lee Law School in Lexington, Virginia. Professor Drumble's most recent book, aptly enough, is called Reimagining Child Soldiers. We've lost the cover art, which is beautiful, but you can at least see this book here has really, I think it's fair to say, revolutionized the discourse and the thinking about child soldiers. Mark has written extensively about this issue and a number of other issues in the field of international criminal law, and I know he has some interesting remarks to make about the issue of child pirates as well. So I personally look forward to his comments forthcoming. Finally, at the right extreme, though not the politically right extreme, of the panel, we have my good friend, Milena Stereo, who, as many of you know, teaches down the street, Cleveland State University. Professor Stereo has her own book, not specifically about children, but about the right to self-determination under international law that just came out earlier this year or last year or late last year, hot off the press. Professor Stereo also has the dubious distinction of teaching me. Before she began her brilliant career at Cleveland State, she was an adjunct professor at Cornell, where I had, she had to deal with the likes of me in her international war crimes seminar. So, without further ado, I will hand it over to Shelley Whitman. You guys all have about 15, 16 minutes to make your presentations,
Yeah,
okay?
You give me the time.
I think you guys are the timekeepers? Yeah, so look out and they will tell you where you are. Thank you.
You guys are going to speak from up there. Just bring this up so that our
Oh, sorry. I thought it was such a recognizable face that everyone would know. Thank you very much for having us here today, and thank you, Michael. Last year we met, I was part of the Dalhousie Marine Piracy Project and leader of the socioeconomic section of that report. I had that opportunity to meet Michael, and we started to discuss about future plans here at Case Western. So I'm pleased to be here, my first time to Cleveland, and thank you for the warm welcome. Today, what I want to talk about is the use of children in maritime piracy. If you do a Google search and you put in child pirates, you're going to come up with all kinds of Halloween pictures. And so when we started to do this work, it was very important that we say, well, it's not, we need to have some qualifiers here so that we make it very clear for people. I'm hoping that some of the work that we've been creating means the Google searches are changing a bit and actually having some impact as well on this particular issue. As part of the Dalhousie Marine Piracy Project, looking at the socioeconomic factors, this was one of the major pieces that came out from it, was the use of children in marine piracy and how it's really an underlooked issue. I am not a lawyer by training, so I want to let you know that this is not going to be a legal discussion. This is going to be one that's going to be far more about setting the stage of how children are used and recruited, and about the impacts that that has overall in terms of piracy, and what are some of the practical ways we could try to address this problem. I'll leave the legal dimensions to the lawyers who are sitting to the right of me on the panel. So if we look broadly at why this issue needs to be addressed, 6 of the countries most affected by piracy are among the 15 most fragile in the world. And we need to look at root causes that was talked about in the previous panel, and the human factors that are related to piracy if we're going to really look at developing a solution. So laws are great, wonderful, but there are root cause elements we have to address. And increasingly, there's been evidence to suggest that children and youth are being recruited by pirate gangs. And most definitely, we need to have a more systematic collection of data on this particular issue. However, collecting data means, first of all, you have to get people to be aware that it is an issue to collect data upon. And that's one of the things that we're going to talk about, is the fact that actually we need greater awareness amongst everybody who is trying to combat this issue, from the lawyers to the navies to the private security companies to the shipping to the child protection workers to those looking at it from judicial authorities in countries that are addressing it, from Kenya, Seychelles, and now to West Africa and other particular contexts. Who is a child pirate? We have developed a definition based on the Paris Principles definition of a child soldier. The UN Convention of the Rights of the Child declares that a child is anyone under the age of 18 years. I know that Professor Drumble certainly has a viewpoint on this issue and about what problems that creates. However, in light of what exists currently, this is the definition that the UN and the world has seemed to grapple onto. Paris Principles definition really looked at all of the multiple roles that children play when it comes to their use in armed conflict. And I think that's very important in this context of child piracy, that it's not just about the kid with a gun who boards a ship. There are all kinds of support functions and roles that children can undertake that are critical to the success of a piracy operation. So in terms of the definition we have put up there, we talk about it being any person below 18 years of age who is or has been recruited or used by a pirate gang in any capacity, but not limited to children, boys and girls, used in as gunmen in boarding parties, hostage guards, negotiators, ship's captains, messengers, spies, or for sexual purposes. It's not only referring to a child who has taken a direct part in kinetic criminal operations. This is important because stigmas exist about what the imagery is related to child soldiers as well as with piracy. And we've been talking about empathy here. There seems to be a lot more empathy in the world for children who are used in armed conflict, but when we talk about children who are used in marine piracy, the empathy isn't there, and it might go back to the history of the definition of piracy being its, as an enemy, everyone's enemy, right? And so part of that is very important for us to break down if we're going to try to address how this is unique in terms of the use of children. So in terms of the rationale for the use of children in maritime piracy, some people might question, so why are they used or how are they used? Much like the use of children in armed groups, children are vulnerable and easy to manipulate. They're fearless and often unaware of the consequences of their actions. I have 4 boys at home that range from the age of 2 up until 20. I know that they do things all of the time that make me cringe, that I would never do, and that I ask questions to them like, why would you do that? And they say, I don't know, I was bored, or whatever it might be, right? And so the characteristics of children are very important for you to consider in terms of what is manipulated and why they're viewed as valuable. If you couple that with drug use or alcohol use, intimidation, other things related to poverty, and in a lot of the places we're talking about, boredom is a huge factor, right? And in Afghanistan, in Somalia, why children are used, part of it is because what else do they have to do in a lot of those instances? They are cheap. You may not have to pay them at all, and feeding them is generally less than feeding an adult soldier, for example, or in this case, maybe pirates. Plentiful often in many of the developing countries we're talking about. In Somalia, indicators show that the numbers of children below the age of 15 is 50% in terms of the demographics of that country. So the human resource that exists is often young, and so it's therefore not a crazy thought to think that when you need young people to do this type of work that they're plentiful. They're small in stature and therefore nimble. So there can be times when the small stature is a negative aspect. There could be times when it's very beneficial. Easily indoctrinated as well. It's not difficult to tell them that this is how the world works and present a worldview to them, and they may believe in that. You tell them that this are the kinds of benefits they will get out of participating in this, right? Money, weapons, access to certain types of activities, drugs, and they will very much believe that that is the case. So the socioeconomic factors that put children at high risk of recruitment and use by armed groups also exist in those countries most affected by piracy. In Sri Lanka, there's a perfect example with the LTTE, where they use child soldiers and also use those child soldiers in piracy operations. So we have other examples around the world where this has existed. I'm putting up this slide about the recruitment of child soldiers in 2012. These are official numbers that have emerged from the UN's SRSG on children in armed conflict. So these are the reported numbers. It could be much different because there could be a lot of unreported cases that we don't have unsubstantiated. But what's significant about this graph is Somalia and the numbers of children that had been recruited in 2012. I'm relaying this point because what I'm going to get across to you is that I think we need to take a look at the fact that when we have times of conflict, children can be used in a particular way, such as in armed conflict, child soldiers on the front line, spies, messengers, all of those types of things that they take on. There's a skill set that they develop. You might think it's a negative skill set, but it's a skill set. And when armed conflict ends, that skill set doesn't go away. And oftentimes there are vacuums and voids that are created in which we need to be really looking at the fact that they can also be manipulated and used if we don't have good rehabilitation, demobilization programs, and that goes across into other types of international or criminal activities that we need to address. When we first started to look at this issue, in terms of getting a handle on the numbers, we looked at the number of pirates on trial up until 2011 at this point. And in terms of the numbers on trial and the numbers of those who were under the age of 18, these were the numbers that we could find. So a significant number that have been put on trial and captured. These are the ones we know of. We don't know how many more may have been just dropped off on the coast or who may have been released after, certain procedures took place, and on a national level if there might have been other measures taken. The use of children in terms of marine piracy qualifies under the ILO's term the worst forms of child labor. I'm highlighting this because we talked in the previous panel about the need to look at other mechanisms for how we might deal with piracy. So the ILO and its Convention 182 related to this issue is something that hasn't been explored fully, and we need to look at that as potential as well, so that it's also about the use of children in terms of the worst forms of child labor. I'm putting up this graphic here because what I want to show to you is that we are trying to get across about how children can go across the different dimensions in terms of wartime and peacetime. So much like the idea of factories that in peacetime they may create automobiles and in wartime tanks, we have similar viewpoints here when it comes to the use of child trafficking, child soldiering, and criminality, and how this applies to piracy, is that the same individuals who, or not the same, but similar types of individuals who can be shadow facilitators can create the context in which in a peacetime children can be used as pirates. The same skills as I explained can also be transferred to the use in armed conflict. I'm bringing this up in particular because right now you will hear a lot of people saying, well, why would you be concerned with piracy off the coast of Somalia? It's been reduced so greatly, and look at all of the wonderful efforts in terms of naval patrols and in terms of how to address this from a legal perspective. And I think it is good that we've had all of those potential dynamics come together in this context. However, if we don't address it, and if we simply think that we get to ourselves to a point where it's we've managed it and the problem is over, and then the money that is being poured into that context to address it moves away because now it's bigger on the west coast of Africa, or attention goes elsewhere. If we don't address this from this root cause perspective, all we do is create a situation where currently Al-Shabaab, who is using a lot of children, and the piracy networks are still in place on the west or the east coast of Africa, can merely be taken from one form or use and be re-employed again into the piracy. And we have seen kids who have left and crossed across those borders, who have gone from Al-Shabaab to being used in piracy. And I'm not sure about the backward movement, but it's a possibility that exists as well right now. So we need to look at preventative action, and we need to look at how this is really critical in terms of addressing piracy overall. In terms of the counter-piracy operations, the use of children is important in terms of both the operational and legal responses. So different legal responses are needed, different operational responses are required. There are some moral and ethical dilemmas that appear. And we have to look at how we need to be innovative and create ideas related to strategic complementarity across different sectors. For example, I spoke with Rosamel last night, and she was saying how even child protection actors within the East African region are saying, we don't want anything to do with this issue. So when you're trying to find those who should be advocates of children, even those who are, they're not aware of why they should pay attention to this issue and how we need to address it differently. I said about the operational and legal dynamics, so it's very important that we look in terms of security sector training, naval forces, but also in terms of the private armed guards that we talked about as well. This has an impact on them too, both in terms of the post-traumatic stress disorder that can be created, as well as the fact that we saw how if they are not trained on evidentiary procedures, or if they're not reporting in terms of disaggregating data, that it will have an impact on us being able to address it from this perspective. The last few things I want to just relay is that it's important that we look at community engagement, community level dialogue, media campaigns, looking at prevention. Very interesting that this former pirate head is being used to go into communities or to talk to children about the dangers of it. These are the types of things that we need to start a dialogue on, is about how we raise awareness about the danger of it and engage communities on it. Before I get booted off the stage, I will just tell you that in terms of holistic solutions, we really, as I said, need to look at the legal, the operational, the community level, the child protection agents, and the fact that we have to try to address the demand for piratical activity if we're going to have any impact on the use of children, and how the use of children has a direct impact on the prevalence as well of the use of, prevalence of piracy around the world. My very last point is just that a lot of discussion has been brought up about West Africa. West Africa, what I can tell you in West Africa is the extent and use of children in several armed conflicts in West Africa will have an impact on those who are ready and available to be used in piracy activities in West Africa as well. So if we don't want to pay attention in this instance, I want to say it here and now that it will be an issue that will rear its head on the West Coast as well. Thank you very much.
Thank you, Shelley.
Oh, thanks.
Also hailing from Canada is Professor Mark Drumble, who will be speaking to us about child piracy and legal, specifically legal mechanisms to deal with that. Thank you.
Well, good morning, everyone. It's a real joy to be here. It is probably my, I don't know, 4th or 5th time to Cleveland. All my trips to Cleveland have only been because of Michael Scharf and because of Case. So I guess it's fairer to say it's my 4th or 5th time to Case rather than Cleveland. But I do have the opportunity to see some of Cleveland along the way. I would like to talk to you today about rehabilitating and reintegrating child pirates and the existing legal framework that exists for that. Shelley made a great point in opening up, which is if you do Google search child pirates, you do see a broad array of costumes, and you all will be comforted to know you will also see increasingly a lot of references to the work that she and the Dalhousie University is doing on this particular issue. So there is some diversification, at least on web searches. Where there's not yet a diversification is in popular culture. So my 4-year-old son, about 2 weeks ago, was invited to a pirate-themed birthday party. And of course, we had to get pirate stuff for him for the pirate-themed birthday party. And it was very odd. He was at the party, I dropped him off, I left, I went to the office, and I started to write on the real child pirates in the world while other people were playing pirate. And at the end of the day, I think a conference such as this that highlights these issues is incredibly valuable. I would like to make 3 major arguments here today and share them with you. First, I think when we think of child pirates, there is a lot to learn from how we think about child soldiers. There's also a lot to learn from the way we fall short in thinking of child soldiers. Second, I would like to emphasize that the emerging paradigm to deal with child pirates is a criminal law paradigm. We can celebrate the criminalization of piracy and the emergence of criminal law frameworks for this. But what I feel has been lost in that shuffle and in that celebration is a good accounting of what the place should be of juveniles within that framework. And I believe there has been a lack of attention focused to international children's rights within this emergent criminal framework. And to me, that is relevant because there have been juveniles, persons under the age of 18, caught up in criminal trials at the national level in the countries indicated on the prior slide, and also, I believe, in more countries than just that. And I can talk about some of those cases a little bit later. The final point that I would like to make is I believe that in looking ahead, the way we ought to approach child piracy and the rehabilitation of child pirates is neither through a criminal law model nor through this capture and release, you're all innocent, you're all used, and you're all abused model. I believe both of those models fall short, and instead I would argue for a model that focused on restorative justice mechanisms in which pirates who are youths implicated in piracy come forward, seek forgiveness, have conversations with victims, contemplate a broader form of reintegration that comes with responsibility, obligation, as well as societal and international obligation to maximize the best interests of former child pirates. Now, let me start off with the child soldier, child piracy analogy. Child pirates are not child soldiers unless they are members of a national armed force or an armed group that is in the process of engaging in armed conflict, and that is simple juxtaposition of the core definition of what is a child soldier. Okay. Another important point to recognize is, however, that there are analogies and similarities within the process by which young people become enmeshed in pirate gangs. My greatest source of frustration with discourse and dialogue on child soldiers is that it basically breaks down into two binaries. There's two images that float out there when we think of the child soldier. The dominant image is the child soldier as a faultless, passive victim, helpless, hapless, used, and abused, having no responsibility for what happens in times of armed conflict and no responsibility for how he or she ended up in situations of armed conflict. That image, at least, is motored by a spirit of compassion. The other image that's out there with child soldiers is the image of the child soldier as a demon and a bandit, incorrigible, a Clockwork Orange style imagery. And that image views the child soldier as unsalvageable and irredeemable, something to be very frightened of and something that cannot, in many ways, be rehabilitated. And I use language like something because a lot of the discourse about child soldiers can actually be deeply depersonalized and dehumanized when it comes to seeing former child soldiers in this image. These are the two images. They're both incorrect in terms of not being attuned to the actual realities of child soldiering, and they're both counterproductive in many ways. What I find frustrating is that in the small emerging discourse that's starting, that's picking up speed on child pirates, I see a replication of both of those images and both of those metaphors in the context of child pirates. On the one hand, there are some groups that borrow from the helpless imagery of the faultless passive victim, and there are others that view child pirates as incorrigible criminals to be prosecuted regardless of their age. Shelley is absolutely right. I think there is more of the demon and bandit image attached to child pirates than actually has been attached to child soldiers in the past. And I find that very interesting as to how that framework came to be. I see an analogy between child pirates in this regard and child terrorists. Because within the framework of young people that commit acts of violence that could constitute international crimes, child terrorists don't benefit from the same benevolent viewpoint that child soldiers do in terms of being viewed as faultless passive victims. And I think our own national discourse here over individuals such as Omar Khadr, or individuals, young people who engage in suicide attacks or in terroristic violence, we don't view those individuals as helpless kids. We view them in many ways as deluded, menacing adults. And I see to some degree the child pirate being viewed in a similar sense than the way we view the child terrorists, minus some of the histrionics that often accompany conversations about terrorism. So, point one, there is an imagery that is associated with child soldiers. It's being imported into the child piracy context, and I think it's counterproductive. This has led to the whole-scale adoption of criminal models to deal with captured child pirates, or, on the other hand, immediate capture, release, and amnesty. And in many ways, the immediate capture and release of former child pirates, in my opinion, simply risks recidivism. It simply risks that youth returning to criminal activity, whether piracy or whether some other form of criminal activity. On the other hand, penal law, sanction, and punishment, with its goals of retribution and deterrence, I believe are not well suited for young people caught up in acts of piracy. The language of the criminal law, in particular international criminal law, is often ill-suited at dealing with themes such as restoration, rehabilitation, reparation, making amends, and reinsertion into society. Therefore, I would say that in order to move forward in a deeply constructive way, we ought to be considering a third path, a path of restorative justice. You can't have that path, though, if you use as your predicate the notion that all young people in piracy gangs are there because they're forced to be there. I think it is very important to explore the motivations that lead young people to enter piracy gangs. Yeah, this is because of poverty. Yeah, this is because of poor opportunity. Yeah, this is because in some instances family members, neighbors, friends are engaging in this and people just follow this in a path dependency. But young people are not shorn of agency, authorship, input, or all forms of autonomy. And at the end of the day, we have to recognize that these factors may pull young people into acts of piracy, but it's often a logical calculus. It's often making the best of a bad situation. It's often maximizing the handful of opportunities that you may have that actually draws young people into situations of piracy. And I don't think you can remediate that without acknowledging that there is a level of authorship, agency, and activity that motors people to join pirate gangs. I also believe it's very important when we talk about any form of international criminality in which young people are involved to not invest so much in the chronological marker of the age of 18 or 15 or whatever chronological marker you want to use. The fact remains that approximately, and this is very anecdotal, approximately 1/3 of pirates that sometimes are captured in raids tend to be under the age of 18. But an awful lot of them are also in their early 20s. And very, very few are very, very young. And at the end of the day, I think we need to view age as something on a continuum and not a bright line. Because when we take it as a bright line, we have the same problem that we have with the child soldiers. Everybody under the age of that, the benchmark age, 18, is viewed indulgently as having no authorship or responsibility and being able to discharge no obligation. But everyone over the age of 18 is not given the benefit of the doubt, is not given any excuse. Yet we know that when you're 19, 20 years old, you are also in a process of cognitive and neurobiological evolution. And at the end of the day, when the law draws a bright line, it falls down hard on those just over it, while it indulges those right under it. So I think that's another very important point to bear in mind, and an important point for us to recognize when we talk about this. That said, international human rights law, as presently formulated, does fixate on the law, on the age of 18. And look, we're lawyers, you have to apply the law as it is. And international humanitarian law and international human rights law in particular stipulates that upon apprehension and detention, if you're under the age of 18, you have to be treated in a certain way. You have to be segregated from an adult population of defendants and detainees, that you have to remain separated from that particular constituency. And the Convention on the Rights of the Child, it doesn't say that minors cannot be prosecuted for criminal offenses. It doesn't say that. It precludes the death penalty, and it precludes life imprisonment without parole. Fine. But it doesn't say that minors cannot be charged criminally or prosecuted. But it does say that some accounting must be made of minority status in that particular process. And when we have a situation where persons under the age of 18 are mixed up willy-nilly and indiscriminately with adult defendants and prosecuted in a group equally, without justification for why the minor is included in that group, that begins to flirt with impermissibility under international human rights law. Therefore, I would strongly encourage states that are in the process of enacting national regulation and criminalizing piracy nationally to have account of the age of the person in the kinds of procedures that are set up, and for juveniles to be treated differently within the framework of the criminal law. All states have national ages below which persons are not capable of having penal responsibility. That sort of generally ranges between the ages of 7 and 14 under national law, if you did a survey. But at the end of the day, between the 14 and 18 bracket, account still needs to be had in this regard. I have a minute left, and I'm going to wrap up on the following note. There's a lot to learn from what we did and what we're doing with child soldiers. You can make an analogy with child pirates. My takeaway from the analogy and looking ahead would be to develop a middle ground between the neglect and carelessness of capture and perfunctory release, and what I think is the excessive and ill-fitting retributive approach of criminal trials when it comes to youth engaged in piratical activities. The only way we can reach the middle ground, though, is to strip ourselves of the rhetoric that dominates the intersection of children and international law. A rhetoric that either sees young people as troublemakers or young people as innocent souls used always by evil adults. We need a middle ground that recognizes the humanity, dignity, autonomy, agency, and vivacity of youth. The fact that with rights comes responsibilities and durable reintegration. And to this I would say not only of persons under the age of 18, but also of low-ranking pirates over the age of 18, many of whom may first have entered piratical activity as minors, requires the investment of effort and time in restorative justice mechanisms. And let's talk about one group we haven't yet talked about necessarily all that much in this framework, and that is this. Piracy not only costs money and costs lives, it also creates a broad array of victims. And victims of piratical attacks also ought to have some form of justice. But their demands for justice and the need for stability in international maritime and public orders requires us to think much more creatively and assertively. And to date, our focus on penal law and our congratulations to ourselves for penalization ought to come with a little asterisk. And the little asterisk ought to be that the criminal law can only take us so far. And when it comes to rebuilding societies from where pirates depart as a point of origin, there is also something to learn from broader transitional justice frameworks, and those broader transitional justice frameworks suggest a need for this sort of creativity. Thank you very much for the opportunity to be here and for your time.
Great. Well, thank you, Mark, for those very enlightened comments. I'm sure we'll have a lot of discussion afterwards about some of the comments you made. The last speaker is, I'll grab your name tag. So, our last speaker is Professor Milena Stereo from Cleveland State.
Thanks, Tim. It is also a pleasure to be here for the third or fourth time, and I hope I will not disappoint you by basically mostly agreeing with Shelley and Mark, so there will not be any controversial dispute here going on among the panelists. But let me just take this opportunity to build on some of their remarks, and what I will do here is focus mostly on the specific legal obligations coming from international law that follow the states that apprehend and prosecute pirates, and then more specifically, I will focus on, in a concrete situation when a state apprehends a group of pirates and then either brings them to its own courts or transfers them to a third state for prosecution purposes. What are those states supposed to do? What kinds of concrete measures can they undertake in order to respect their international legal obligations with respect to the treatment of juvenile pirates? And even though I do not disagree with Mark in his point about the fact that having this bright line rule that says that anybody under 18 is a juvenile, anybody over 18 is not, and the fact that we maybe need to rethink that in my remarks today, I will basically assume that everybody under the age of 18 is a juvenile, anybody over the age of 18 is not. So for the purposes of today, let's just assume that when I speak of the treatment of juvenile suspects of piracy, I mean those who are under the age of 18. So Shelley had already put up some numbers in terms of suspected pirates that have been apprehended or prosecuted and who have been juveniles. So let me just follow up on some of those numbers, give you a few additional numbers. So for example, in March of 2011, an Indian vessel, naval vessel, apprehended a group of 61 pirates. In that group of 61 pirates, 25 were under the age of 15 and 4 were under the age of 11. In France, and this was on Shelley's slide, 1 out of 6 prosecuted pirates was a juvenile. In Germany, 3 out of 10. In Malaysia, 5 out of 7. And we even had a case in the Southern District of New York here in the United States where the defendant alleged to be a suspect, and the judge ultimately ended up basically refusing to treat that defendant as a juvenile and determined that the defendant was an adult. So that case, we don't have a clear conclusion as to how old that defendant was. Shelley has already talked about, and Mark as well, they've both talked about the root causes of juvenile piracy. Why do young Somali boys engage in piracy? Probably because of poverty, lack of better things to do, displacement, separation from their families, limited social and educational opportunities, exposure to violence and armed conflict. Now, when a naval fleet or any kind of a law enforcement officer of a country detains a group of suspected pirates, what happens then if one of those pirates or suspected pirates looks to be a juvenile, or what happens if one of those suspected pirates claims that he is a juvenile? And to paraphrase Judge Duncan Gaswaga, who was the piracy judge in the Seychelles, who unfortunately couldn't be here today, what do you do when you have a grown man with a beard who tells you he's 12? Do you, take his word for that, or, do you have to do something about that? So first, let me briefly speak about the international law on the treatment of juveniles, and then let me briefly tell you about some of the things that states can do in order to respect those obligations. So under international human rights law, the International Covenant on Civil and Political Rights has 2 specific articles that deal with juveniles. So Article 10 of the ICCPR basically says that accused juvenile persons shall be separated from adults and brought as speedily as possible for adjudication. So the obligation to separate juveniles from the adult population to bring them to trial as speedily as possible. And then Article 14 says that procedure shall be such when we deal with juvenile suspects as will take account of their age and the desirability of promoting their rehabilitation. So anytime you're dealing with juveniles, you have to take into account their age and also think about the desirability of promoting their rehabilitation. The second treaty that I will mention here that Mark has already mentioned is the Convention on the Rights of the Child. And Mark is correct when he says that the convention does not prohibit the criminal prosecution of a juvenile suspect, but the convention does say that basically the arrest, detention, or imprisonment of a child shall be in conformity with the law and shall be used only as a measure of last resort and for the shortest appropriate period of time. And then it also says things like juvenile suspects should be separated from the adult population. They should never be sentenced to the death penalty or life imprisonment without the possibility of parole. They should have the right to contact their family members. They should be brought to trial as speedily as possible, and that measures shall be taken to basically take into account their age and also provide for educational rehabilitation type opportunities for the juvenile suspects and possibly those who are then convicted. Now, those are the major international human rights treaties that speak about the treatment of juvenile suspects. Now, what about international criminal law? And so Mark has already spoken about the parallel between child soldiers and child pirates. And here, let me just take a brief moment to look at the practices of the international criminal tribunals. And obviously, we have not had any piracy prosecutions in the international criminal tribunals, but because at least some scholars have talked about the possibility of either bringing the crime of piracy within the statute of the International Criminal Court or of establishing a specialized ad hoc international piracy tribunal, I think the parallel here is very, very important. So the statute of the International Criminal Court says that the court does not have jurisdiction over anybody who is under 18. So in the ICC, the current ICC system, anybody who's under 18 could not be prosecuted. But the ad hoc tribunals for the former Yugoslavia and Rwanda did not have any such specification, and so presumably a juvenile defendant could have been prosecuted in those tribunals. In the Special Court for Sierra Leone, nobody who is under 15 can be prosecuted, leaving the possibility that those who are between 15 and 18 could be prosecuted, although the prosecutor there has said basically that the tribunal would not prosecute anybody who is under the age of 18. The Cambodia Tribunal does not have any mention of a minimum age of international criminal responsibility, but it does incorporate Article 14 of the International Covenant on Civil and Political Rights, which basically states that procedures in case of juvenile defendants should take account of the defendant's age and the desirability of promoting the defendant's rehabilitation. So while there's certainly no consensus in international criminal law about the age of minimum age of international criminal responsibility, I do think that there is some consensus about the fact that any time we're dealing with juvenile defendants, that they ought to be treated differently, distinctly. Somehow that they ought to be treated better than the adult defendants. So taking all of that into consideration, what is the state supposed to do when it apprehends a group of pirates, and again, when there's somebody in that group who either looks to be very young or who claims to be very young? In the first instance, I think it would be relatively easy for the apprehending, capturing nation to separate all those who look to be young or who claim to be young from the rest of the apprehended pirates. For the most part, suspected pirates will spend days or weeks on board the vessel of the capturing nation. They will not spend years or decades in captivity there, and so it seems to be relatively easy to separate those who appear or claim to be juveniles from the rest of the detained pirates. So that part is relatively easy. Now, what happens when that group of pirates is then transferred to the prosecuting nation? And here it can either be the same country, or in many instances the pirates are transferred to a third country for prosecution purposes. What happens then? What should that nation do? So one thing that we all, I think, need to agree on is that that nation does not necessarily have to take the word of the suspected pirate that they are 12 or they're 15. So again, when you have a grown man with a beard claiming to be 12, obviously you do not have to believe that person. The difficulty here is that apprehended pirates do not travel with passports or national identity cards. And so, and many of them, frankly, might not even know exactly when they were born. So they might not even know their age. When interviewed, many of them might claim to be younger than 18, realizing that this will somehow result in a better treatment and result in a lighter sentence. There are medical scientific procedures that the prosecuting nation can use in order to determine the suspect's age. So for example, we do have DNA examinations, x-rays, dental examinations. All those things, if conducted by a specialist, can lead towards not necessarily, determination that the defendant was born on May 1st, 1990, but some kind of a determination of a possible age range. And keeping in mind, by the way, that here we might be talking about slightly skewed results because somebody who grew up in an impoverished country with a lack of proper nutrition might, appear to be much younger than they actually are. So, but nonetheless, the exam, the scientific or medical exam, can lead us to some conclusion about the person's age. And I think conducting a medical scientific exam is a much more appropriate procedure in light of these international human rights standards than simply saying, you know what, we're not going to believe you, right? We're going to treat you as an adult suspect. And here we actually have an example from a U.S. case. So in the Southern District of New York, one of the suspected pirates who was prosecuted back in 2009 claimed to be 15. So basically claimed the right to be treated as a juvenile, and the judge in that instance refused to conduct a medical or scientific examination. Instead, the judge interviewed this pirate suspect, interviewed some other claimed to be friends or family members, and determined that the suspect was an adult, treated the suspect as an adult, and handed out a 34-year sentence. So in light of international human rights standards, probably not the best procedure, to be followed. In some other cases, in some other states, judges have ordered medical scientific exams or have simply treated suspects as juveniles if they, appear to look as juveniles. So let me just mention another Judge Gaswaga case from the Seychelles from the summer of 2012, so slightly a year ago, where a group of pirates was apprehended, prosecuted in the Seychelles. The adult pirates were sentenced to 30 years in prison. A 16 and a 17-year-old pirates were sentenced to 2.5 years in prison. And then a 12-year-old defendant was sent back to Somalia, where Judge Gaswaga simply determined that this suspect could not face any kind of criminal responsibility. And apparently an effort was made to locate that suspect's family members in Somalia, so when he was transferred back to Somalia, he wasn't simply released on the streets of Mogadishu. Instead, family members were contacted and the pirate was handed over to those family members. Now, that catch and release attitude when we're dealing with juvenile suspects, I would agree with Mark Jumble, is not the ideal solution either. And so I have to agree with Mark here that the ideal solution does seem to be some kind of penalty combined with rehabilitation, education, retraining. And of course, the difficult question, the elephant in the room, might be, well, if juvenile pirates are prosecuted in the courts of a country that is a member of major international human rights treaties, basically then it is the obligation of that state to provide for those opportunities, which might be very, very expensive and which might entitle then the juvenile pirate to stay there indefinitely. Because under major human rights treaties, it would be a violation to simply send that kind of a juvenile pirate back to Somalia if we suspect that the person will then be mistreated or would not be provided with these opportunities. So just to conclude, I'm running out of time and I would love to have time for questions and answers. States have the obligation to treat juvenile suspects differently from the adult suspects. They do have the obligation to attempt to determine the person's age, and they do have the obligation to provide some kind of rehabilitation, educational opportunity for the juvenile suspects. But I sincerely hope that because those things might be very, very expensive and time consuming, I sincerely hope that that will not be something that will turn off states like the United States or, Western European states from taking on juvenile piracy cases. I think the best thing that can probably happen to juvenile pirates is to end up in some kind of a, juvenile detention facility in, France or England or Norway or the United States with educational rehabilitation opportunities. Thank you, and I think we'll move on to questions.
Great. Well, thank you, Professor Sterio, for those comments. We have 7 minutes by my reckoning to ask questions. We have a question already, so I don't need to exercise my moderator's privilege. Please.
I didn't hear either of you discuss whether or not any investigation is done into the willingness of the juveniles to participate in activity. They may be the victims of intimidation, kidnapping, or other force to coerce them to participate. What is done there to, one, find out if that is the case, and two, how are they treated differently if that is the case?
If I can say a few remarks about that. I mean, I think that was one of the things I was trying to highlight, is that there are different circumstances to how children are used than to how adults are used. Now, I think what Mark has been talking about is about the need to look at each individual case and understand that you can't just have a blanket prescription for everyone. I agree that that is important for us to have an approach to this that we have to refine as opposed to what we've dealt with previously. However, that's one of the key problems, is determining. How would you determine whether or not they have been coerced, or how would you determine whether or not they have been forcibly recruited into it? Because that's why there's been an approach previously to simply say that if you are used in that particular manner, no matter how you were brought into the context, you are a child, and therefore the ability for you to make clear decisions about joining or participating in that type of activity is difficult for you to have full knowledge to be able to determine that. So that is why a lot of child protection and human rights activists have taken that type of approach, because determining that is often very difficult to determine.